How to get a divorce in the UK. If you and your spouse have separated, it's likely that you're considering divorce. However, there are many factors to consider before taking this step. First of all, there are many different types of divorce available in England and Wales. To get a divorce in England and Wales, you must show that your marriage has broken down and that it meets at least one of the 5 facts set out in the divorce petition. To get a divorce in England and Wales, you must show that your marriage has broken down and that it meets at least one of the 5 facts set out in the divorce petition. The court will look at each of these facts before deciding whether to grant you a decree. You can use these rules to check if your case is eligible for an uncontested divorce. Adultery. If one party has been unfaithful while married to another person, then they are entitled to file for divorce on this basis alone without showing any other grounds. This means that adultery is considered one factor which may be used when assessing whether or not there has been an irretrievable breakdown. In order for someone's marriage should end with no further recourse being required by either party involved after receiving legal advice from their solicitor beforehand so as not waste any more time unnecessarily. After 12 months have elapsed since filing such paperwork with their local registrar office, whereupon they will issue new paperwork indicating such outcome without having anything else left over which needs attending once again. You can get a divorce if you've lived apart for more than 2 years and both agree to the divorce. If you want to get divorced, then it's important that both parties agree on the terms of the divorce. You can file for one if your husband or wife agrees with you and doesn't contest it. If they do contest it, then there are several ways to handle this. You can file an uncontested divorce in which both parties agree on everything from child custody arrangements if applicable, alimony payments, spousal support payments and property division properties. This is called a simple divorce because there are no legal battles between spouses over who gets what when they split up after living together for more than 2 years plus the days spent apart. If one spouse refuses to sign their name next to I consent when asked by the court registrar during finalization hearings which happen after 6 months of separation but before finalization proceedings begin. You can get a divorce if you've lived apart for more than 5 years, even if your ex disagrees. If your spouse agrees, you can get a divorce if you've lived apart for more than 5 years. You'll need to prove that the marriage has broken down and that it's no longer working. You also need to prove that at least 2 years of separation, no more than 5, have occurred. The law doesn't say how long this separation should be, but in practice, it's usually between 3 and 6 years. Your spouse must agree to the divorce if he or she wants it to go through, otherwise, there will be no proceedings against him or her at all, even though he or she may have been aware of their partner's desire for a divorce for some time before this point in time. If you have been separated for less than 2 years, you can still get a divorce but both parties will have to agree to this. If you have been separated for less than 2 years, and both parties agree to the divorce, then a decree nisi will be granted. However, if either of the spouses is unwilling to give their consent for divorce, then it will be necessary for them to apply for an interim order before applying for a final decree nisi. You can get a divorce if your spouse has behaved so unreasonably that you cannot be expected to live with them. This is called unreasonable behavior. Unreasonable behavior is a legal term, not a personal one. It means that the other person has behaved in such a way that makes it impossible for you to continue living together. This can include physical or sexual abuse, extreme violence, and emotional abuse. For example, if your spouse has threatened you with violence or threats of violence. You can get a divorce on the grounds of desertion if one partner leaves another partner without consent, or has left home without a good reason or agreement between the couple, after 2 years of separation. You can get a divorce on the grounds of desertion if one partner leaves another partner without consent, or has left home without a good reason or agreement between the couple, after 2 years of separation. The following are some examples of what constitutes desertion. Leaving your partner and children for at least 6 months. Being violent towards your spouse. Refusing to pay maintenance payments for children up to age 16 or any other dependents. Staying away from home for more than 7 nights in a row unless you have been granted leave by an order made by the court. The UK's definitions of what constitutes a marriage breakdown are very specific, but they do allow for flexibility given certain circumstances. The UK's definitions of what constitutes a marriage breakdown are very specific, but they do allow for flexibility given certain circumstances. The law in the UK has based on the premise that marriage is a contract between two people who wish to enter into it and make every effort to create an enduring relationship. However, if one partner becomes unable to fulfill their obligations as defined by this contract, then there may be grounds for divorce. Therefore, if you find yourself in this situation, then it's important that you have legal advice from an experienced solicitor who can advise on how best to proceed with your case so as not to leave yourself open for future legal challenges which could further damage your financial situation after divorce proceedings have been completed successfully. Conclusion: divorce can be an emotional time for both parties, but it does not have to be. If you are considering divorce and are unsure about how to proceed, we recommend that you seek legal advice from a solicitor who is experienced in this area of law.